recognize the member for Fredericton Southern, leader of his party.
Merci, Monsieur le Président. Well, so we have the first substantive bill of this government, Bill 2, Mr. Speaker. And so this is going to be the very first test of the Premier's commitment to make the New Brunswick, the new legislature, work differently, or to make it work. In the throne speech, there were commitments to enable committees to hold hearings and call witnesses, and have committees investigate and develop instead of simply responding to legislation, Mr. Speaker. Already we're feeling the pressure. It's urgent. Got to get this through. That's not the way we get good legislation done, Mr. Speaker. The leader made a series of recommendations, the Premier, when he was leader of the opposition, made a series of recommendations to all the leaders in the House about further ones that weren't in his throne speech about how to make the legislature committee system and the process of dealing with legislation work better. My caucus and I agreed with all of them, and we indicated that to the now Premier, Mr. Speaker, and made some additional suggestions. So, as I said, this is the first test. There's the working group's recommendations that were made, but then there's the question of how they get implemented in legislation. That's the key thing, to make sure that while there was lots of agreement around the recommendations of the working group, the devil is in the detail in terms of whether they're being appropriately implemented in Bill 2 in legislation. So that's the key thing. One of the reasons we're here, Mr. Speaker, dealing with Bill 2 is because in 2013, amendments to legislation dealing with Worksafe New Brunswick were rushed. There wasn't proper study. There were if there were amendments, they weren't properly considered, and that set up the situation, Mr. Speaker, which this bill in part is trying to fix, where people whose workplace injuries are long healed and they have other problems unrelated are still receiving compensation, or people who retire are still receiving compensation for workplace injuries, and so on. Things that need to be addressed. I agree. But those came as unintended consequences of a bill that was rushed through this Legislative Assembly without proper consideration, without witnesses, without study, adequate study, without hearings, without serious consideration of reasonable amendments. Some of these problems could have been avoided, Mr. Speaker, if proper care had been taken. Now, this bill, well, first of all, before I talk specifically about the bill itself, Bill 2, I do want to point out that one of the reasons there's been such a dramatic change in the rates that businesses are seeing is that the Commission essentially rated the Workplace Fund to keep those rates artificially low over a number of years. So we go from 170 to 292. But Mr. Speaker, it's very clear that for years the rates were held artificially low by dipping into the fund to subsidize those. All you had to do was look at Nova Scotia and see that they were paying about $265, or sorry, $2.65 per $100 payroll when ours were well under $2. So why the inequity? Well, it's because the fund was being rated to keep rates artificially low. And that was not mentioned by the minister, and I think it needs to be set in context fairly. There are other reasons rates are going up, yes, absolutely. I'm not saying that this is the only thing that's going on here, but I think it's appropriate to give the right context to what's going on with rates. And dampen down, turn the volume down a little bit on the sort of crisis and urgency of this. We've all received presentations from the business lobby, of course, but also in my office I see injured workers who have not been well served by the current system the way it stands. In fact, there's an injured worker who's been out sitting in the rain, in the parking lot, in the snow, in the parking lot here behind the Legislative Assembly, Mr. Speaker, because of a mistake that was made. And he was unsuccessful in having that mistake redressed. And so now he's living in his car. That's where he lives in his car. He's lost everything and has serious health problems, which are not being assisted by him, of course, being out in the rain to plead his case to we, the members of this Legislative Assembly. But I do want to say, with respect to the bill, in implementing the recommendations, it does a number of things which need to be investigated, Mr. Speaker. It increases the discretion of the committee itself and reduces the discretion of the appeal tribunal. So, for example, if you look at a section of the bill here, 18, where it says the Commission may, in its discretion, diminish the compensation to which a firefighter or former firefighter is entitled, or suspend payment of that compensation in the following circumstances, adding one that we haven't seen before, which is if the firefighter or former firefighter persists in dangerous and unsanitary practices, imperiling or impeding the rehabilitation of the firefighter or former firefighter. Well, Mr. Speaker, how is that going to be determined? There's nothing in the bill that suggests how that might be determined, or how, in the first place, that workplace might determine that that firefighter or former firefighter is persisting in dangerous or unsanitary practices, as defined by whom, Mr. Speaker? As defined by whom? So this is one little example of why we need to seriously look at this bill and have the ability to hear from witnesses, Mr. Speaker, like representatives of the firefighters. What do they think about that? I'd like to know. Similarly, Mr. Speaker, the bill includes a section on Section 34 here, which gives the Commission exclusive jurisdiction to establish policies consistent with this Act and other legislation, including the Occupational Health and Safety Act, for the purpose of determining entitlements to the benefits of this Act. Well, Mr. Speaker, does that remove the Minister's ability entirely, when it's necessary and urgent in the public interest, to establish public policy governing this very thing? Some will argue the Minister should have no role. But I'll give you an example, Mr. Speaker. Under the Occupational Health and Safety Act, the standards for air quality in industrial workplaces in this province have been, until recently, decades old. Decades old, Mr. Speaker, long when they'd been in other jurisdictions and other countries, modernized, reflecting the evidence, reflecting the actual science, the risk involved, and we, for decades, had low standards that came out of the 1970s, Mr. Speaker, in terms of safeguarding, or supposedly safeguarding, the health of working people in their workplace from the air they breathe, or the contaminants and particles in the air they breathe. Now, Mr. Speaker, if the Minister, and I don't know if this does this, so, you know, this is a question, one of the kinds of questions you would want to ask a witness with the expertise to tell you. But if the Minister doesn't have that kind of ability in that kind of a situation to say, no, we in fact are going to bring our standards up to a level that are reflective of the current science, the evidence, to minimize the risk to workers of the contaminants and particles in the air they breathe in their workplace, well, then that's a problem. I don't know if it's true, but this is the kind of thing we should be able to have the opportunity to ask witnesses. Mr. Speaker, one of the things that Labour in particular was pleased about achieving in the working group recommendations, that was ending the three-year waiting period, Mr. Speaker. But, Mr. Speaker, you wouldn't want to get injured just after this Act passes and expect that your three-day waiting period is gone, because you would have to wait 3 years for that to happen. This bill will not eliminate the three-day waiting period until July 1st, 2021. What does Labour think of that? So this is what I mean by interpretation, Mr. Speaker. Labour was very pleased with the decision, the recommendations of the working group to get rid of the three-day waiting period. But did they think they were going to have to wait till July of 2021 for that actually to fully kick in? An important question for MLAs to ask representatives of Labour, Mr. Speaker. And so that's why we need that kind of opportunity. So that's clearly an issue. Mr. Speaker, the bill includes a section where the Commission, this is 4115, where the Commission may in its discretion diminish the compensation to which a worker is entitled, or suspend payment of that compensation in circumstances where the worker persists in dangerous and unsanitary practices imperiling or impeding the rehabilitation of the worker. So again, just like the firefighters, Mr. Speaker, who is going to determine, well, first of all, how are they going to find out that this is going on, and two, who is going to determine what consists dangerous and unsanitary practices that imperil or impede the rehabilitation of the worker? I don't know how this exists in law, Mr. Speaker. And so in addition to hearing from labor, I'd like to hear from a legal expert in occupational health and safety who understands, and workplace issues, who understands what the implications of this are, Mr. Speaker. And I can't imagine why MLAs on committee would not want to hear that opinion and have the opportunity to ask those questions, Mr. Speaker. So these are just a number of examples, Mr. Speaker, that are important. A final one I'll mention in terms of examples, Mr. Speaker, is up until now the Appeals Tribunal has been able to receive information they feel is relevant to the case they're hearing, the appeal they're hearing, and that ability will be taken away, Mr. Speaker, will be taken away. So that removes some discretion from the ability of the Appeals Tribunal to do its job to serve the worker who is appealing the decision of the Commission before the Tribunal if they cannot receive relevant information that otherwise might not be admissible in an actual court of law, Mr. Speaker. And so this is an important diminution of the powers and authority of the Appeals Tribunal to hear, receive relevant information in the case before them. So these are important issues that need to be addressed, Mr. Speaker, at committee in a way that makes gives us the ability to understand the implications, to ask questions of those who would be impacted negatively as a result of these changes, and how they see them, whether it's representation from business or representation from labor or representation from experts. To make this legislative assembly work, Mr. Speaker, we need to have those opportunities with this bill, Mr. Speaker, which is why I'm going to move an amendment that the motion for second reading be amended by deleting all the words after the word "that" and substitute the following, that Bill 2, an act respecting addressing recommendations in the report of the Task Force on Worksafe New Brunswick, be not now read a second time, but that the order for second reading be discharged and the subject matter of the bill be referred to the Standing Committee on Law Amendments.